The advantage of not speaking first is I can pick up some of the points raised by some of the other speakers. I was particularly interested in what Jay was saying about the prosecutor at the International Criminal Court. I've written quite a lot about Luis Moreno Ocampo. I think he's a disastrous prosecutor. He's been in post for more than 6 years and doesn't yet have a single conviction to his name. And it's very interesting that he chose to consider more than a year ago whether it was possible for Palestinians to bring Israel to the International Criminal Court without going into the legal issues. This would depend on whether Palestine is a state. Now, I think we all know there can be some argument over the attributes of a state, but Palestine does not have the attributes of a state. And yet Luis Moreno Ocampo has chosen for more than a year to keep this question open when any first-year law student would close it within a moment. And the reason for that, of course, is that after having launched an arrest warrant for President Bashir of Sudan, it suits him to be able to say that he is being, as he would say, even-handed in keeping open this possibility, a ridiculous possibility, that the Palestinians can take Israel to the International Criminal Court. I did actually doorstep Mr. Moreno Ocampo, as we say in the trade. I interviewed him at a press conference in Dubai last summer, and you can hear the result on my website. I was interested in what Anne was saying about legal action being brought by Al-Haq. I have got a press release that they issued last month in London. Al-Haq, a human rights non-governmental organization based in Ramallah, West Bank, have a legal challenge being heard by the Court of Appeal over the UK's international obligations in respect of Israel's actions during Operation Cast Lead. And it's quite interesting, really, because what they are trying to argue is the courts in Britain have jurisdiction in some way. The response of the British government, which is the defendant to this action, is that the case is not justiciable, meaning that it's not an appropriate case to be brought before a court, and also that Al-Haq does not have sufficient legal standing to bring this case. And I think those arguments will be accepted, but as far as I know, we haven't yet heard the result of that judgment. Now, that is just one of several cases being brought in the courts of England and Wales that are comparable. This week, for example, the Court of Appeal was hearing a case brought on behalf of 7 former detainees, some of whom were held at Guantanamo Bay, some of whom were held in other facilities. They claim of unlawful extraordinary rendition, and they claim that the British government should have done more to avoid the breaches of their human rights. They say they were subject to torture, to other inhuman treatment. And this is quite a substantial case. The British government says there are 250,000 documents, of which 140,000 are classified as secret or above. And the last thing the British government wants to do is to disclose those documents to the lawyers acting for these former detainees, who are obviously, by definition, suspected of, though not convicted of, terrorist offences. And the question that's occupying the courts at the moment is what is required by our rules of disclosure. We have principles that if I bring a case against you and you have information in your possession, then you're required to disclose it to me so that I and the court can understand the basis of the claim. We do have an exception for documents that are subject to public interest immunity, but under the law as it stands, it's a question for the courts to decide. The British government is arguing that they should decide what documents to be withheld. Just a couple more cases to set this whole thing in context. I suppose it all began with the Pinochet case. You remember the former Chilean dictator was out shopping in London one Christmas about 10 or 11 years ago, and he found himself arrested, and he was held under house arrest outside London for nearly a year until doctors persuaded the British government that he was too ill to stand trial, and he was sent back. And that, I think, showed people what the courts could do if people were unwise enough to come to London. Another chap who is discovering this is a man called Eyüp Ganic, who was the former president of Bosnia. He was arrested in London on Monday of last week at the request of Serbia, where he's wanted on war crimes trials. He was held in prison until this morning when he persuaded the courts that he should be granted bail. So that's really the background to lawfare. The one other point I wanted to pick up was from Richard's very powerful speech just now, Richard Heidemann. It's very interesting that he was encouraging lawyers here to use the courts to do something within the law to stand up against terrorism. Now, we're here to discuss lawfare. Is that lawfare? If he is encouraging people to use the courts, our program here says lawfare is the use of the law as a weapon of war, and Richard referred to fighting the war on terror. If the fight against terrorism is a war, something that isn't widely accepted in Britain, but that's a matter of definition. But if you say that it is a war, then presumably if you're using the courts to stand up against terrorism, you are using lawfare. Now, I'm not for a moment trying to equate the lawfare that Richard is talking about, if that's what he is talking about, with the sort of cases that I'm about to describe. But it does perhaps just give you an inkling of how it is possible for people to think that the courts can be used for some purpose that they, the people concerned, think of as respectable. I was in Ramallah in the West Bank a couple of months ago, and I went to a Palestinian human rights organization. And they were talking to the British Attorney General, Baroness Scotland, and I was in the room when she was talking to them. And there were two things that they said which struck me as quite interesting. First of all, they said implicitly that the reference to the International Criminal Court that I began this talk with was not going to get anywhere. They acknowledged that Palestine was not a state, and they acknowledged that there was no opportunity, therefore, to bring Israel before the International Criminal Court. But the other thing that they said to the British Attorney General was that really they had no option. They had no other way of bringing their concerns before a court, because they said they couldn't bring legal action in Israel. Now, I'm not for a moment justifying their concerns, but they were pleading with the British government not to abandon the principle of universal jurisdiction, which they hoped would enable them to bring their concerns to the courts in London.